Mhm.
Yeah. Yeah. Okay, everyone, as we have conducted this discussion session before, we will encourage you to use freely the chat box by respecting each other and also give, like a thoughtful insight in there. So we will have a very interactive session in this discussion session, of course. So talking about the judicial investigation, as we have shared to you guys the materials and also the presentation for today's session, we have known for the, like initial thoughts that judicial investigation as the part of judicial process that put investigating judge to conduct the pre-trial investigation. Of course, there will be so many questions. There will be so many, like unique insight of it. We will discuss it with our distinguished speaker, Miss Jessica, that will be introduced by Mbak Ajay.
Okay. Hello, everyone. Hello, Judge Jessica. Is it okay if I call you Judge Jessica?
Absolutely. I'm happy to be called anything.
Okay, Judge Jessica. So from what I heard from Mas Bagus, that you are famous, kind of famous, or well known as the first Khmer woman to pass out the West Point. Can you tell us about that?
Oh, yeah. Okay. I was about to introduce my military career. So I went to West Point 16 years ago, fi- 16, 17 years ago. So a long time ago. Um, and yes, it's a military academy, but there was also law available there. Therefore, I went to West Point and studied law. And then I left West Point and ended up at military court.
Oh, I see. So you started as a military, then you entered West Point, then you studied law, and after
Yes,
that,
yes.
you changed job to being a judge. Is it
Yeah,
correct?
yes, yes. So now I am actually in the civilian sector as a judge, out
Okay.
of needs for
Okay.
the Cambodia judiciary because it's very young and it
Mm-hmm.
needs a lot of change and work inside of it.
Okay.
So yeah, this is where I am now.
Okay. That's so great. Maybe Mas Bagus can show us the picture of
Wow, where
you.
did everyone get this photo?
So when we Googled your name, we can find like a lot of picture of you in your uniform as a military. It's so cool, honestly. That's so cool.
Dang. So you guys already stalked me, so
Yeah,
you
yeah.
have all my information now.
Yeah, we already stalked you before. So yeah. So can you tell us more about you know, why you decided to change the job from the military court, then you decided to be a judge in the civilian court?
Well, it's basically out of a need of judicial reform. Um, Military court is one thing, but the nature of military law is a bit different than
Mm-hmm.
civilian law.
Mm-hmm.
And due to the government's reform agenda for the judicial sector, and due to my international education, so
Mm-hmm.
afterwards, I also went to get my master's of law
Mm-hmm.
in England in international human rights law. And we have a little bit, some human rights issues that we need the judiciary to be aware of. Equality of arms, due process. And
Mm-hmm.
that is something that Cambodia is trying to work on very hard to make
Oh,
sure we have good judicial due process.
okay.
Has something been criticized somewhat for. So
Okay.
therefore, I've decided to join to help out to ensure that we're able to adhere to international law in our civilian sector where all the eyes are on us.
Wow, that's so cool. I mean, like you learn a lot uh overseas and then you want to make a good change in your country, then you decided to move to the civilian court. It's really inspiring, actually. Thank you, Judge, for the story. Okay, everyone. After we heard a bit from Judge Jessica here, we actually want to make a breakout room at first. Maybe you guys already read a bit about the PowerPoint presentation that we shared before in the WhatsApp group. So we will kind of discuss it a bit in our breakout room. Maybe we can like, what is that, Mas Boy? We can list some of
Yeah.
the questions that we want to ask to Judge Jessica later.
Yeah.
So
So
maybe
yeah.
we can continue to breakout room, Mas Boy.
Yep, right. So basically, for all the audiences here in breakout room, we will, just make sure that you are in this discussion by showing what do you think and what actually
What
raised
do
up
you
in your mind about this topic. We can make it in two breakout room. The breakout room one will be led by Mbak Aziza, and the second one will be led by me. While Judge Jessica, you can also join us in
the breakout
everywhere
room?
you want.
Yeah.
Yeah.
Absolutely.
Okay, so we're
Thank you.
basically we'll just maybe raising our question about the issue. What do you want to know later and ask to Judge Jessica? So we just want to make sure that everyone is really jump in this discussion. It's only like about 5 or 10 minutes for the breakout room at first, then we'll continue with the material from Judge Jessica later.
Yeah.
Okay. Mas,
Okay, I will.
can you make the breakout room, Mas Boy?
Yep, I will.
I already make it, so you guys just wait a minute. And I also want to say hi to my friend. Hello, Jessica. Uh,
I think they have already gone to the breakout room.
okay, Mas Boy.
Okay, thank you.
But Aze, I have to go a little bit, but I will come back.
I can share screen from my laptop, right?
Yeah, you're already the co-host.
Okay. Okay. Thank you. Don't be too long.
Thank you, thank you.
Okay,
Okay,
hello
yeah, sure.
everyone.
Aziza. So it was a very, like interesting discussion in our breakout room.
Nice.
Yes. Before we start, we have already had so many questions,
Mm-hmm.
so many, I had so many questions, and I think we have so many strong point in it. How about your breakout room?
Yeah, it's actually my breakout room is a little bit shy cat, you know. They are a bit shy, but Mas Ivan and Mbak Amel already gave us their opinion about the judicial investigation, and I'm pretty sure that our discussion today will be so interesting.
Yep.
Okay,
Okay.
maybe we can start with the discussion with the presentation from Judge Jessica. So, Judge, the judges here are really excited to hear about your criminal justice system, and especially about investigating judge that you will be present after this. So we're waiting forward to your presentation, and I'm going to. Can you share screen, boy? Wait for a bit.
Oh, I'm not sure actually.
Let
Wait.
me try. Um,
Would you like me to do the screen sharing for
uh,
the
uh, Actually, Mas Bagus already gave us the PowerPoint presentation. So
wonderful,
yeah, so we will try to share screen so you can focusing on your material.
wonderful.
Okay.
So Judge Jessica, just confirming, in your presentation session, is it okay for you if anyone probably interact with you during your presentation, or we will wait?
No, no.
At the end.
You should ask as many questions as you want
Okay.
whenever.
Okay.
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 Okay, so
So
everyone, uh, Judge Jessica already giving us her permission to dive in. So if you think that at some point you need to ask something or you need to, give your thoughts about the presentation, just do it. Feel free because this is our forum and we really want to know. I am pretty sure that we all here really excited to learn so much from Judge Jessica. So just feel free to ask, don't really scare about pronunciation or something. We will try to help if you are kind of confused and maybe you forgot about the word. It's our rule. It's our first rule in our English club, right? Okay, so please, Judge Jessica, the room is yours.
Thank you very much. First, I like to say that thank you to the whole team and to Judge Backus for giving me the honor of joining your English club. And a little bit about learning English. It's just like learning anything else. You really have to jump right in and do it. So it's you get better the more you force yourself to make as many mistakes as possible, and then you make more mistakes, but
Yeah,
then you get better over time.
yeah.
So just my little encouragement to everyone here to speak. Uh, as you all have known, I've been introduced as Judge Sithyka Jessica Meach, Judge Jessica. Um, you've heard about my military background now. I'm honored to be here, but I will be here to talk a little bit more of our judicial system, specifically the investigation judge. Now, this topic came up because Judge Bagus and I were joining a seminar on environmental law together. and we were talking about why judges in Cambodia were so much more busy, is because we have to do investigation work too. And it was a foreign, not a foreign concept, but it was wild to Judge Bagus because as I understand, in the Indonesian system, it's done mainly by the police and prosecutors. And even the arrest powers is also quite different. So I will be taking us through all of that today. Next slide, please. So today we'll hit through 8 different items, but feel free to stop at any point to discuss any point of those items. Can we go next slide, please? Intro to investigating judge. I would like to say that investigating judges, they're independent judicial officer. And this is the difference between the Indonesian system where you have prosecutors or you have police doing it, because police and prosecutors, they work in the interests of the state. So they're a party to the cases. Whereas an investigating judge works for justice. They work for the truth. They don't work for anyone but the truth and justice. Even the state, they don't work for the government. So the investigations are supposed to be independent. It's supposed to ensure both sides, but it's mainly used for serious crimes to make sure that the overwhelming power, the overwhelming money that the state has doesn't cover over the individual. And this is basically an inquisitorial system. It's as opposed to the other system like the United States or all other common law countries. They use the adversarial system where the police or the state or the prosecutors on behalf of the state does their own investigation. The defense lawyers and the defense do their own investigation. And it sometimes lead to what we call the equality of arms. They have to balance the defense against the prosecutor. But we don't have that because we have an actual impartial judicial officer conducting with the power and money and resources of the state. So, but we don't work for the state. So it serves that different portion of the imbalance. Next slide, please. So this is very summary brief of our criminal process and where the investigation judge power and duties would lie, but very brief overview, and I'll go a little bit more detail. But we have, I would kind of say 3 or 4 stages, depending on how you want to break it down. But we have normally the preliminary investigation by the royal prosecutors. So the royal prosecutors would conduct investigation, supervising the police. So in our system, the police works for the prosecutor. And whatever initial gathering of information is conducted under the supervision of the prosecutor. But for complicated cases, serious crimes, or felony, in our law, you have to submit it for judicial investigation. So it's like almost another check on top of what the prosecutor and police are doing. And this is basically what we have in the pretrial investigation and the pretrial procedures. So it's not just the investigation. The investigation judge is also responsible for pretrial procedures too. But I'll go more into that in a little bit. And only if there is enough evidence to go to trial is there a formal indictment. So I know in a lot of system, the prosecutors, they do the indictment or grand juries do the indictment. But in our system, the formal indictment after an investigation, a judicial investigation comes from the investigating judge. And they will send that to trial. But the investigation judge and the trial judge cannot be the same people. They have to be different judges. So it's a long process, but it's supposed to it's designed to be accurate. So it's long, but it's designed to be accurate. Next slide, please. Now a little bit more deeper into the duties and responsibilities. This is in the pre-trial stage. So nothing, all the information, you have a preliminary information already, but the idea is that the judge oversees the criminal investigation. And they oversee complex or serious crimes or felonies. So even if it's not complicated, it still falls under judicial investigation to make sure that everything is accurate. And gathering evidence. This is what I talk a lot about with Bagus that he thought was completely wild, was we will collect evidence ourselves. We will go down to crime scenes if we feel like it helps us understand what's happening better. If it helps us make our decision better. We will order expert reports or conduct searches or you even look at evidence ourselves to make sure we're gathering the right ones. And in all of this, we have to look at both evidence that are inculpatory as well as exculpatory. So in favor of the defense as well as in favor of the prosecutor. We have to look at both evidence and look for it, actively seek out all the evidences. And in that, part of the gathering information process for the investigation is the interviewing of witnesses and suspects, even to summon for interrogation victims and witnesses is all done under the watch of the investigation judge. And warrants as well, authorizing arrests, detention, wiretapes, searches, that is all under the powers of the investigation judge. Next slide, please. And under this arrest, we have if there is a need for detention, the suspects or the accused in this case will be placed in pre-trial detention by the investigation judge. So but detention here is seen as a process to secure the investigation to trial. So if there's evidence enough to detain and it looks like it's going to trial, then that is part of the investigation power of the judge as well, just to ensure that the accused can go to trial. Or, of course, if the evidence is strong, but the accused, again, we're not determining guilt at this stage. We're only determining that a trial can happen fairly and impartially. So if the accused complies and have certain conditions, they can apply for bail. And that is the investigation judge's power as well. And of course, deciding on prosecution. So the formal indictment comes from the investigation judge. And this is why the judges usually, I don't wait for the reports to come. I go down to do my own investigation if I need to. I don't wait for the report from the autopsy. I will go down and see for myself the bruises on the bodies if I need to, so I can understand the situation. Because at the end of the day, I am deciding on the prosecution. So I send the person to trial. And if the evidence is strong enough, I will usually send the person to trial. Or if the evidence points to it, but it's a determine of guilt or not. You have to understand the investigation judge does not determine guilt. Only determine if there's enough evidence for the person to stand trial. So you're not deciding guilt beyond a reasonable doubt to send to trial. You are only deciding if there's enough evidence for the person to stand trial, or it's just someone complaining and that's it. So it's a protection of both the state investigation as well as the defense's rights. So in that, the duty is ensuring fairness, because the judicial officer, we work for fairness, we work for justice. So we are neutral. We don't have to make arrest quotas like the police. We don't have to follow state policies and defend state policies like the prosecutors do. We only need to make sure that justice is being served. We don't respond to government officials asking us, why are we not getting drug people out of the street? So we work for justice, and that this allows us to ensure that police and prosecutors, they don't overreach, and we protect due process for a person as well. So this is why we have to look at both. In English, we would call it inculpatory. Inculpatory meaning guilt, evidence of guilt. And then exculpatory meaning evidence proving that you're not guilty. So our duty is to look for both evidence in our investigation. Not like the police, where they usually don't look for both. They just look for evidence of guilt. They only look for inculpatory evidence, and that's their job. That's it. So in the adversarial system, you have to wait for a good defense lawyer team. And if you don't have that much money to hire a good defense lawyer team, then you know that the state has a better resource for investigation than you do. That's why the inquisitorial system was designed, was to balance out the adversarial type disadvantages. Next slide, please. So, as you said, as you have heard throughout my presentation, I've sort of balanced it out for you to see the different sides of it. So in comparison, an adversarial system in most common law countries would be very common, like United States and England. Investigations are conducted by the law enforcement and prosecutors. They're not by judicial officers, and defense and everyone gathers their own evidence, and then the judge just sits there and waits for it and weighs the evidence back and forth and whether it's beyond a reasonable doubt or anything. However, the checks and balances in a common law country is that they have grand juries or preliminary hearings for big or complicated cases that serves as a check before trial. So not everything goes to trial too. They go through a grand jury hearing or preliminary hearing, and there's usually a judge that hears the case and says it's not evidence enough, and then they don't go to trial too. So that's their use of a pretrial judge. But our system, which someone asked the question in our breakout room, is designed and modeled after the French criminal law system. French criminal, it uses a Germanic legal route. So Belgium, Germany, they all still use that inquisitory system. Spain, you go back, they all still use that same inquisitory system, but in France, I think it's called the instruction judge or something. And they still play a crucial role up till today as well. So Cambodia very much models our criminal system of the French Criminal Code. Next slide, please. So now we talk about the pros and cons, because I know a lot of judges here think, wow, that's a lot to do, but there's also some good, some bad to the system. So let's talk about the cons first before we go to the pros. As you, every country who has this system argues about how much money it costs the state. It's very slow and bureaucratic. So a criminal case can take a year, up to a year or more, to process through to make to trial. So it's very slow and bureaucratic, because in our criminal procedure, we have, as an investigation judge, we have to follow through certain procedures and steps to show that we've done a thorough investigation so that we can come to our decision. So this process, to do all these process, can be very slow for the accused and for anyone who is involved. And therefore, it's a very slow process, and it costs the state, it costs the country a lot of money. And again, it's limited in scope. So it's very limited in the way that some judges cannot go out and do all of it. The power of the judge to go out and fully investigate, like prosecutors, like police, is still limited. So in that limitation, like we cannot sit and surveillance a house, for drug trafficking. We cannot do some limitations of investigation that police and prosecutors are very good at doing. We cannot do stakeouts. We cannot do, embedded investigation. So it's very limited in the way that our investigation has to be whatever the judge is able to conduct. And it causes also less flexibility in the procedure. So when you have a felony and you have full evidence, everything, nothing needs to go to investigation because everything is there already, you still have to go to an investigation judge. So the flexibility for the prosecutors and for the police officers to respond to ever-changing crimes. For example, today, because we are very limited in our scope, we can only investigate what the prosecutor sends to us. So if all of a sudden the crime is an organized crime with 500 other crimes involved, it has to push back and forth to the prosecutor. We cannot react to what we find in the investigation like law enforcement can. So if all of a sudden we were asked to investigate a detention, an illegal detention, but then we discovered that it was a drug trafficking ring, a human trafficking ring, all sorts of other issues, the procedure makes it that we have to send it back to the prosecutor. So it's not very flexible, whereas the prosecutors or the law enforcement, if they discover that upon their investigation, they can just expand their investigation. So judicial investigation is very limited because of the idea that it's supposed to be a check and balance. So it's not full power over everything. It's a check and balance over each other. And the pros. So the pros is that, again, we have a balanced evidence collection. So we balance, like I said, I reminded you about the inculpatory as well as exculpatory evidence. So we're not just the police officer or prosecutor looking for guilt. We're also looking for evidence showing non-guilt. And of course, it's a check on prosecutorial power. The power to decide arrests, detention, and everything that can violate a person's human rights gravely is determined by a judge, because we think a judge can balance all these human rights issues much better than someone who just works to find guilt, to find crime. And through this, thorough and impartial investigations can occur, which is why we think that this allows judicial independence as well. We're not bound by what the prosecutor sends us. And on that, the trial judge is not bound by the investigation judge either. But they have to decide based on what they see the investigation judge pushes through. So it's almost like more than two judges looking. For a felony, we have 3 judges trialing. So it's a lot of judges. The idea is a lot of judges and a lot of ideas to make sure it's as accurate as possible, the judgment and sentencing at the end. Next slide, please. So on the international law stage, it's actually something that the international courts have discussed a lot. And at the ICC, although the office of the prosecutor, they still do most of the investigation, but the pretrial chamber, they start to do warrants and case dismissal as well. So warrants and detentions and all that arrests is also part of the pretrial chamber, which has sort of an investigation judge duty as well. But the difference is they do not lead the investigation. Cambodia itself actually had an international tribunal for our tragic past in the 1970s. And we used this formula on the international stage with the United Nations, where we had an investigation judge chamber where the judges did very similar functions to what I just told you about. And I think with that, I complete my presentation for you today. Next slide. Any question, thoughts, or comments? This is where the discussion. I'm excited to hear everyone's thoughts and whether you think that this is, as a lot of people say, like in France, they argue about how much this costs the state. So they try and get rid of the investigation judge a couple of times because of how much money they think it costs the state. But I think the discussion now is still to keep the investigation judge because there's no replacement for it at the moment.
Okay. Thank you, Judge Jessica, for the insight about the judicial investigation. It was a really interesting concept, as we already heard before, and I see there is already one person raise his hand. It's Mas Adlan. Okay, Mas Adlan, room is yours.
Okay, thank you. Thank you, Judge Jessica, for the wonderful presentation. Actually, I'm a bit interested in several areas, but I will try to make it quick. First is about you say that the process is supposed to be accurate, very accurate and very, but you also said that it also slow and very bureaucratic. Is it any specific time or any regulation that rules about the duration of each stage, or you can just do it for how long it may be there? And then the second one is you said that the pre-trial judges does not determine whether the convict is guilty or not. Actually, I'm really interested about what is the minimum requirement for the judge to render a decision or a sentence in Cambodia, because in Indonesia we need the minimum of 2 evidence and the confidence of the judge to render a sentence.
Mm.
And I think the last one is are you doing it all? I mean, like, do you do it all by yourself, or you can seek for support from the another institution, or do you have any assistants or court clerk that there to help you? I think that is my three question. Thank you.
Okay, thank you, Mas Adlan. Okay, so Judge Jessica, do you want to answer this first?
Yes,
Okay.
let's because there's a lot in that. That's
Okay.
that's very good for discussion. So I will say we do have a duration after 12 months. After 12 months, the parties meaning the police, prosecutors, or the defense, anyone that is involved, or the civil complainant. So I don't know if you have the same system. I haven't even gone into this yet. Alongside our criminal system, you can also, if you're the victim of the case, you can also file a civil case that parallels to the criminal case that depends on the criminal case. So the civil complainant, the victim, can also file for the investigation judge to finish their investigation within 1 year. You can extend that with good reason. You have to do a decision to extend your investigation, and it has to be a reasoned decision. You have to, because we work off what we call the case file. So you have to put it in your case file showing why you need a longer time to investigate. But 12 months is when everyone around you, prosecutors, the lawyers, the civil complainant, the accused, has the right to ask you to finish your judicial investigation. I have done judicial investigation. My longest ones have been 2 years. But that was a transnational, international money laundering case. So it took a long time for the evidence to come back and forth internationally. So durations, there is stipulated in the law. So we're a civil law country, so everything is, our criminal procedure is all in our criminal code. To render a decision for sentencing, it has to be beyond a reasonable doubt. So like you said, the confidence of the judge that there's no other explanation for the crime other than the person committed reasonably. So that's what beyond a reasonable doubt is that you cannot reasonably explain it any other way that this happened that way. But to send to trial, you do not need to go beyond a reasonable doubt. This is for the trial judges to decide. But to send to trial, you only need evidence that is strong enough, that is what we call preponderance of evidence, meaning it's maybe. And then the trial judges decide whether that maybe that you found as an investigation judge is beyond a reasonable doubt or not. It's not for the investigation judge to decide guilt or no guilt. The investigation judge only looks at whether it may have happened or not, and is it enough for the person to argue that in front of a trial judge. And that's all. We do have some misapplication of it, where the judges themselves have determined whether the person is guilty or not, but that's not how the system is designed. Amit, is there a hand?
Hello? No,
Yes.
no.
Okay.
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 Is
Is there,
this one-
and
Okay.
who helps us? So
Yeah.
final question, right?
Yeah.
Yes. So when you are investigation judge, you have the power of the state. So you have the power of the state. That means you can ask for any state agency to cooperate with you. You can ask for immigration to do certain things at the airport for you, to find you this person at the airport, or to arrest this person at the airport before boarding or something. You can ask for the police. Technically, you can ask for the police to go help you find this person somewhere because you think that they're there. So all we have to do is write a decision who we're asking to you, who we're using our judicial power to command. And as long as they work for the state, they have to respond to you. So and if I need, for example, this hospital to provide me details of this person, I will write as the investigation judge with a warrant asking them to provide me with whatever I need. And if I need to go check a building, say I'm investigating a scam building and I need protection, so I will send my investigation, my requirement to go check the building to the local police officer. Or if I'm worried that the local police officer is working with the building, I will send it to a different police officer and ask them to come with me to the check. So as an investigation judge, you have the ability to use every local source or local state sources under your disposal, and they have to respond to you.
And you don't need the warrant when you want to do it.
No, you do, but you are the one who issues the warrant.
One.
Yeah.
Like very powerful.
Yeah. Yeah.
Okay. Thank you.
Mhm.
Okay. Thank you for the answer, Judge Jessica. It's actually shows how powerful the investigating judge is, because in Indonesia, we don't even have the power to give out warrant, you know. We cannot really ask a hospital to give us some information. It's all in the hand of a prosecutor or the policeman.
Yes.
So we actually also have the civil law system, but in practice, it's a bit, I'm not quite sure how to say about that, but we don't really have that much power. We basically just, you know, take whatever they gave to our courtroom and try to make a reasonable decision from that. So it's really uh on their power by prosecutor to prove that someone is guilty, and the defense attorney to prove that they are not guilty. We only can do whatever they can give us. It's That's all. So it's really cool to hear that in Cambodia you have that so much power to make sure that the human rights is being served and the justice is being served. And when you say about giving the same chance for the both, because you can find the evidence that is prove someone guilty and prove someone that is not. And in Indonesia, because we can only check on whatever they give to us, if someone doesn't really have a defense attorney, and then it's kind of end for them,
Yeah.
because they enter the system without any defense attorney, and the prosecutor, of course, already have this pile of evidence to make this person go to jail. So it's quite cool, in my opinion. How do you think about that, boy?
Yep. It's from my side, that's really interesting, because there is a strong power in judicial investigation system in Cambodia, of course, to the investigating judges itself as well, right? So, Judge Jessica, you have mentioned the power, and you have mentioned we have the state power, right? even though we have the state power, yeah, the challenges is still a real, right? You want to go to investigate it directly, and there are so many factors that can affect you in the field itself. How can you describe to us about the security itself while you do investigating? Do you have a special or particular security coming from the state or something like that?
So we at court, it really depends on the province. My province has its own, I would say, court security. But when we do investigation, it determines on different security. So if I think, for example, I'm investigating a highly sensitive case that I think local forces are involved, I will request a different force from a different province to come help me. So it's your, I think you as the judge have to really, really use your judgment in what you do, because you do put yourself at risk a lot, especially if you're investigating drug cases or any cases that may have local government, local forces involvement in the issues. You have to be able to judge who you can trust. Trust is a big thing, you know, probably something that you have as well in your own system, where we're trying to change the system, but not everyone is working where you're working. Not everyone has the goal of reform like you do. So in my system, we don't have a court security force that goes with us. They only guard the court. So if I want security for myself, and I always do, I will request for you know, the national police from the headquarters to come down and assist me, or I will use different forces from different areas to come help me if I think that the local forces might not cooperate as well. But because you have that ability to request, it doesn't mean they'll help you. Some forces will be like, no, ma'am, I don't think you should be, Miss Judge, I don't think you, Madam Judge, I don't think you should be going there yourself because it's going to be too difficult to secure your safety. So I've wanted to go down to places where I think are the hub of trafficking drugs, and I've been told not to go by the security forces. Ma'am, we cannot secure your safety if you go there.
Okay.
So it's not that everything we want to do for investigation we can do. There's still a lot of limitations because of our duty as a judge.
Okay, thank you, Judge Jessica. So, basically, the limitation is real as well, right? So they will, you know, like request you not to go, and because due to your, you know, like your safety. Thank you for that point. We have also Miss Novalinda. Wanna say something, please? Yep.
Thank you, Mas Boy. Thank you, ma'am. Swastay Pelford, Judge Jessica. I hope I pronounced that right.
You were perfect.
Thank you. My name is Nova, and I have two questions for you. First, do you consider the crime gravity that is usually used in the ICC in handling heavy human rights cases or just serious criminal offenses? And the second is, do the political matter influences or impacts the judiciary or the judicial process that you handle in Cambodia? That's it. Thank you.
So gravity, the way the ICC uses it is basically based on how serious is the crime for international law. So how does it impact all of humanity? Is basically what ICC uses as their metric. But as investigation judge, it doesn't really matter if it just impacts one person or a lot of people. It's our duty to still use our powers to solve that one problem for that one person. So even if it's just one victim, it's still something that we have to put all our resources in to help that one victim, because we don't see gravity in the case that it impacts everyone. It impacts justice overall. And I think that's the difference in there, where we're not looking at the reach or the impact of the one small act or the one big act or whatever it is. We look at what it means for justice. And if one victim feels injustice, that is something bad for justice overall. So I think that's where the difference is that investigation judge holds this principle of justice very true, regardless of whether it's justice for a lot of people or justice for just one small portion of people. And the next question was, I'm sorry,
About the political matter. Have you
so I would say the political matter, in a real perfect world, political matter doesn't matter. But in our world, political matter always matters. It's, when you're investigating something, what causes impacts on the whole society matters. So it doesn't, in the way when I say political matter matters, it doesn't mean that policymakers or whoever or politicians, what they talk about, all that doesn't really matter because we're shielded by them. But we don't have to respond to politicians. But political matters in the way that, for example, social unrest. So if your decision creates social unrest, for example, everyone, thinks there's a killer out there and everyone's scared. So that desire to make sure the social unrest doesn't happen from your decision making is a very real desire, mainly because whatever decision you make is the property of the country. So it can create chaos or non-chaos on your decision. So that really matters to, I think, a judge, is that. But whatever the politicians say, we're shielded from any political decision making, mainly because we are granted our powers by the king, as you say. Our king ensures that we don't face any political repercussions for anything we do. But I would still say that judges still worry that whatever decisions we make do not create social unrest in our society. Yeah, if that
Okay.
makes sense. And
Yeah.
I think as judges here, I think we all feel that sometimes.
Yeah.
Okay.
Thank
Okay,
you.
thank
Thank
you,
you.
Judge Jessica. But we still have Mas Ivan and Mas Marza.
Yeah.
But before that, Mas Bagus here asked me particularly about the picture of the paper on your desk. I think you sent that last night to Mas Bagus. He really wants to show it here. Is it okay,
go ahead.
Judge? Okay.
So
So, what is this, Judge? Please explain to us what's file is that?
okay, so let me find if I can find it. So this would be my civil cases. So do you see the highlight on there?
Yeah.
Yep. It's
Yeah.
festival.
So that would be the civil cases that I have to handle. It would be like divorce, land disputes. So someone asked in the group, I believe, whether us judges specialize or not. In our law, specialization is there. However, we do not have enough judges to specialize at the moment. So we are aggressively recruiting judges so that we would have a civil law judges, a criminal law judge, but right now we do not. So this is my desk after going to a meeting in Bangkok for 2 days. So I went to a meeting for 2 days, and this is my desk when I came back. And the red, if you can see the red, they all have these red ones. These are the criminal files. So those are the criminal files where whatever investigation is done, everything has to be recorded and put into what we call the docket, the criminal case file. And that is what the trial judge will look at, is through that file, all the investigation done, whether the investigation judge did, a proper summary of their investigation or not. Everything is all on there. So yes, this is my desk. I sent to Vegas mainly because I was a little late with the PowerPoint.
Okay. Okay, thank you, Judge, for the explanation. It's a lot of files, right, guys? Okay, so for the next, I think we can give my friend just comment and said it's not too far with your desk, Bu Aje. He said he said that.
See? So there you go. It's very similar, huh?
Okay. For the next one, we will give the floor to Mas Ivan. Please, Mas Ivan.
Thank you very much, Mbak Aze. Firstly, I want to ask to Mbak Aze, am I allowed to ask a question outside the topic of investigating judge?
I think it's no problem, right?
Okay.
That's
Okay,
Jessica.
thank you very much. Okay, hello, Judge Jessica Mia. My name is Bahara Ivanovich Stefanus Napitupulu, but you can just call me Ivan. I'm a judge in the District Court of Sanggau in the island of Borneo. Okay, so as we know that your honor's country, which is the Kingdom of Cambodia, is a monarchy. Thus, I have a question about a crime related to the monarchy, which is a lèse-majesté. For a short explanation, lèse-majesté is a crime against the dignity of a ruling monarch, and sometimes also including the dignity of the imperial or royal family, where monarch is a head of monarchy, such as emperor or empress regnant, king or queen regnant, sovereign prince or princess regnant, and so on. So the first question is, does your honor's country, which is the Kingdom of Cambodia, have any regulation regarding the crime of lèse-majesté? If it does, I have some other questions, which are, can your honor tell us about the punishment for that crime? And then, besides the monarch, which is His Majesty the King of Cambodia, whose dignity is protected by that regulation regarding to the crime of lèse-majesté? What is the limitation of that crime? Does it include the consort or royal family and other nobility? And the last question is, can your honor explain about the trial procedure of the crime of lèse-majesté? That's all. Thank you.
Okay,
So
thank you, Mas Ivan.
I've not held we don't really call it a lèse-majesté law. We just call it I have to look up the actual name for the crime, but we have it under our law the same way. Now, in all of my understanding, only one case has ever been charged. There has been a lot sent to investigation, but one only was sentenced to trial. And in our law, you can get up 1 to 5 years detention. But it's only against the king. So it's only against our monarch. It's no nobilities, or it doesn't occur against the royal lineage or anything. It's against the sitting king. mainly because I think the argument is that he is our image of the country. So he protects our independence, he protects our image to everything, and therefore we need to protect him. So that is the idea. And so if you allow people, because people now, some people have manners, some people don't have manners. If we allow people to do certain things, it will not allow him to protect us as much if we don't protect him too. Does that make sense? Because even us judges are protected by the king independence. So this means that he has to have very strong image for for us to be able to do our job. The king has to be held very highly. Otherwise, if he's not held highly, there's a lot of things that he cannot ensure. And this ensures not only protection for him, but it's protection for our system that we've developed. But I think I've only remembered one where he was trialed. He was never sentenced to detention in jail, but he was fined for, I think, making fun of or making a video about the king's bad haircut or something like that. But again, like the whole, I'm not defending the law because I know a lot of human rights angle to this sort of law. But the idea in Cambodia is that the king stands for a lot, including the independence of the judiciary. So if you allow someone who has to protect all this, because we're shielded from the state, we're shielded from everyone. So if we allow the person that needs to protect us to be insulted, to be used in any way, that protection of the system also weakens by that, if that makes sense to everyone. So, but we will rarely use this, and it's very, very uncommon to be used. I know it's used differently in other countries. And I know in other countries it's used in their military court, but we use it in our civilian court with proper due process for it. Does this answer your question?
Yep. Thank you very much.
Yeah, thank you, Judge Jessica, for answering the question, even though it's really not, like different with our topic, but it's okay. It would be additional insight for us. Thank you.
Okay.
And then we still have someone.
We still have like 3 questions from
Okay.
the raise hand, but before that, can you answer this question from the chat box? I'll read that for you.
Okay.
So this is from Mas Muhusnul Fauzi. Hello everyone, I'm from Timika District Court. I want to know about judge task in Cambodia. Is the judge there still burdened with non-judiciary tasks or
Yes.
administrative matters in short? Can you answer that?
Yes.
Okay.
No, we have clerks. So I have 3 clerks that works for me. And
Wow.
my chamber has 15 people. So under the clerks, we have 15 admin staff supporting. So my actual chamber, I have 15 people working for me. So so that means I still though have to look over what they do, all the reports. So we have to do reports all the time,
Okay.
um all the administrative things. All the administrative things is what we have to do all the time. And my clerks, I have to look over what they do because they do our admin to make sure, in our investigation, we don't lose any investigations. We don't, because we do a lot. As you can see my desk, I handle in civil and criminal cases. I handled 527 cases last year. So to keep track of all of that, we don't have an admin support from the actual court to help us. We have to do our own internal administration. So yes, non-court judicial stuff, we're burdened all the time.
Okay. So Mas
But
Fahmi said that we're not the
I'm
only one. Yeah.
but I'm curious because someone said we work by ourselves. So
Yeah.
I'm curious about the Indonesian system. What sort of support do you have for you as a judge?
So we don't really have clerk that assign for us privately, but the court got clerks, and the clerks work for every judges in the court.
Oh, you don't have
So,
one clerk that works just for you.
yeah, we don't really have one clerk that assigned just for us.
Oh, okay.
So they work for every judges in the court, and uh, I I'm kind of interested with the one that you said that you have 15 staff in your chamber. So does it mean
So
that the chamber is assigned for you only, or?
yes, so it's my chamber. So I have my chamber. So every judge has their chambers, as we call it. And I suppose we call it a chambers, but that doesn't mean we have just a courtroom to ourselves.
Mm-hmm.
It's just called like I would be Judge Jessica's chambers, and in my chambers we have three clerks, one judge and three clerks, and then everyone else supporting us. So everyone else, the other 12 people that I said are there, they will be our support staff. So they support the clerks, they support our admin, and but they're not admin staff. They're my staff that supports us.
I see. It's nice.
Yes.
Okay, so maybe we will give the room for Mas Marza. Room is yours.
Okay. At first, I'm in deep apologies. I cannot turn on my camera. Okay. The first question is there any difference in qualification of investigation judge and the trial judge? Especially, how about if we wanted to register to be judges in Cambodia? The second question is there any victim, is there any culprit to be set free in the trial, even though the investigation judges is met the role in there? And the third question is if the Cambodian judges feel in danger, is there someone will protect them, or the judges must use their own initiative to report the person make the dangers or not? Thank you.
So I will start with qualifications. Every judge is qualified the same way. Trial judges, investigation judges were all qualified the same way. So qualification is, it starts with you have to have legal education. So you have to have legal education, a degree in law. So you have to have a degree in law to first be eligible. And then you have to have 5 years of legal experience. So whatever the legal experience you have before you qualify to take the national exam. So you take a national exam, thousands, hundreds, millions, I think, apply, but 55 are accepted annually. And those 55 individuals, they undergo judicial training for 2 to 3 years. And the judicial training will train you on investigation judge duties, on human rights, on trial judge duties. So when you graduate, if you graduate successfully from the 2 to 3 years training, it depends. 2 to 3 years. Why? Because it depends on your scheduled program. You have to go to court to do some of your training. So it depends on the court scheduling and everything as well. So it can take up to 3 years, and it can take as little as 2 years, depending on what the program of the court is. When you finish, you are on probation for 1 year. So in there, you don't really handle your own cases. You are on training wheels with, you sit on panels with other judges, but you don't really trial your own, you don't trial your own cases yet. So after that 1 year of probation, there you become what we call full-fledged judge. When you're a full-fledged judge, you can do your own investigation, you can do your own trials. And I will be an investigation judge in one case, but then I could be a trial judge in a different case. So it's not set. We don't have where we have just certain specialization with judges yet. But the qualification is the same for every judge. And I will answer the third question, but I will need clarification on the second question. So when we are in danger, yes, we have to report ourselves to the relevant authorities as well. If we get threatened, if we get, you know, I've been in court where the individual have said to me, Judge, I know what car you drive, so I would be very careful. Things like that. So I will probably borrow someone else's car and drive it for like the next 2 months, but I have to report that myself to ensure that I get the proper protection. And it's something that we discuss a lot now because we're asking judges to do a lot in Cambodia, but we still have not discussed a specialized security forces for judges yet. So to your question, this is something that we've also been talking a lot about in our own internal discussion. So you want judges to be courageous, to be brave, and do certain things in the name of justice. But then in that, you have to ensure that they are safe after being brave, after deciding for justice. So this is something that we also discuss a lot about internally in Cambodia. And for the second question, may I get clarification on the second question again, sir?
Okay, I'm sorry for the
No,
my
it's
bad
okay.
English.
I just didn't write it down in time.
Okay, so the investigation just has been working. I mean, it is make the investigation make more clearly. You need to make it it's clearly an undeniable evidence. But is there any case that even there are investigation judges make the case to the trial, but the trial is decide the culprit is not guilty? Is there any case like that? Thank you.
Absolutely. All the time. All the time. Absolutely. And it depends on your understanding too of certain things. So as specific things too, I think it really depends on the judge. For example, I would say rape cases are the cases that really have different polar opinions and polar understanding, mainly because a lot of female judges would feel differently than male judges depending on the actual incident. So if I push a rape case to trial, it doesn't necessarily mean they will be found of it because there will be things like alcohol involved. You know, the explanation of the facts can be different. And this is why the system doesn't leave it under one person to decide, so that there is a full check and balance. Because maybe I'm a female, I feel a little bit more towards the victim.
Okay.
Yeah. But when, you know, we go to trial, the judge has to think about more of the actual facts. Is it really that? Is the person really a danger to society? Did they really want to commit it? So there's a lot of different and things that are complicated trials usually always end up where trial judges thinks that the evidence is not enough. Like I said, investigation judge doesn't think whether the evidence is enough to convict the person or not. We only think if the evidence proves guilt or not. Or we only think that the evidence is enough for him to go to trial, for a trial judge to look at. And sometimes we push to trial for a lot of different reasons. Because there's a real victim who wants to be heard, sometimes that can also be a reason to go to trial because the evidence is not very clear. So the trial judge has to decide on unclear evidence too. But that's not for us investigating judge to decide. If the evidence is not clear, we don't decide whether it is clear or not. We don't make that tough decision, I would say. I think we get away with not making tough decisions, and the trial judge is the one that makes a tough decision. But we also have to be very fair in saying that we don't put an innocent person, a clearly innocent person, on trial.
Okay, thank you, Judge
Okay.
Jessica.
Mas Boy, before Mbak Amel,
Okay.
we can ask Ibu Nunu Bahtiar. She already raised hand before, and then she put it down, and then she raised that again. So, Bu Nunu, the room is yours.
Please.
Can you hear me clearly, everyone?
Yeah,
Yep,
we
yep,
can
it's
hear
clear.
you clearly.
Yeah, sorry, because I kind of distract with my own icon on the screen. That's why I lower my hand and then I raise that again. I hope that won't be affect all of you. So Judge Jessica, it's a quite interesting discussion, and especially when we come to the fact that you have a very interesting different legal system in your country. So in universal principle, a judge must be kind of a natural and very objective in assessing evidence in a trial. And even in the trial system, the legal system in Indonesia, the judge are not allowed to show the opinion whether someone is guilty or not. So my question is, how can you, especially judge, I mean, you are colleague, right? And you have to like evaluate the work of your colleague. So how can you limit yourself as a colleague, of course, to remain neutral toward the cases that investigate by the judge investigation? And also, can the judge, the panel of judge, call you as a judge that do the investigation to be listened in a court? And also, because we have that kind too, especially when the defense deny all the proof that given to the court. And also, what if the defendant or his lawyer reject all the evidence or investigation from the result investigation result from the judge, where they given the opportunity to review and prove their objection? And also, my question goes exactly the same with Marsha, that have you ever having a cases that you've your investigation being rejected and defendant released by the panel of judges, and if it's so, if it will affect to your performance as a judge? I mean, you given the evidence that not convince the judge, the panel of judge in a court, so they can questioning your work or your performance. Is it come to you also, Akun, Judge Jessica?
Thank you.
Oh, also, I have this another one questions because I have a lot of friends from Cambodia, and they like also like you, like jump from MOG and be a judge with some special training. And so it's very interesting because it's different with us. So can you is it familiar to your system that someone from another institution can jump to another institution, especially as a judge? Also, we have this ad hoc judge, but they cannot handle all the cases, only the special cases. So it's kind of different from you, especially you from military to civil court. So is how can you adjust the difference, and is it easy for you? Thank you, and sorry for so many questions I gave you.
No, it's wonderful. So I would say that one of the good things about our job is that we don't have performance based on how many of our cases get trialed or don't get trialed. So our performance is mainly based on whether I write my judgment in time, whether my investigation are unnecessarily long, whether I fulfill all my cases, whether so right now we're going through judicial reform, and the parties get to submit complaint about the judges if they feel that we are biased or not. So whether I get complaints about me being biased or not by the prosecutors or so your performance is more judged on the quality of your work, not what the result is. So the idea is that you still work for justice. And justice means justice doesn't always mean being found guilty. Justice means being thorough, being very, very well accurate so that you can find the truth for what happened. So oftentimes when I'm unsure about a case and my evidence are balanced, they're 50-50, I will always send to trial because it is not my job to decide whether the evidence says the person is guilty or not. It is only my job to find the guilty evidence, the non-guilty evidence, and have a trial judge decide. So in this 50-50 case, the trial judge can look at it and say, no, I'm not convinced enough. And they do not sentence the person. But I'm not deciding that alone. So there is basically my investigation and another judge's understanding. So the person gets a double check on it. It's not. So this is why it doesn't depend, your performance doesn't depend on how much of your investigation gets found guilty. Because you're not supposed to investigate for people to find guilty. You're supposed to investigate so the trial judge can decide as best as possible, given the evidence that you've presented to them. Now, yes, can an investigation judge, if you do your job correctly, you never need to go to the trial judge and talk about the case at all, because everything is in that docket. The red case file that I showed you just now, everything you do has to be put in there. The result of your searches, your forensic, everything is put in there, and that's what the trial judges looks at. So if you do your job correctly, you never have to explain to a trial judge. And there has never been a situation where the trial judge calls an investigation judge to explain. Now, if you don't do your job correctly and something is unclear, there is a procedure where the trial judge can send it back to investigation to clear any points that's not clear. But it means that the procedure, though, comes back to the investigation judge has to clear out what is unclear. So for example, I did forensics, a rape investigation, but I wasn't clear on certain things in my report, in my summary. So the trial judge pushes back, make it clear that this was tested or not. If the trial judge feels that the evidence is strong enough and they need that to make a decision, then they could push the case file back to investigation. And yes, this is something that will probably be put against your performance. If your investigation was not thorough enough for a trial judge to make a good decision, perhaps that might be something that is on your performance. But I have not seen that yet. So the trial judges either say there's not enough evidence and that's it, and acquit the accused because that's all the evidence that is in front of them, or they say, yes, it's beyond a reasonable doubt. We truly believe this person committed the crime. So, and then they sentence them. And that's one of the good things about being a judge here is that you are not judged on your decision. Our decisions are our decisions based on our understanding of the law and our view of justice. We are protected for our decisions. But we are not protected if we do not conform to procedural law. So we have to follow the procedures. But we do not, as long as our decision is reasoned with proper justification, we are not judged against our decision. And as far as the investigation process, yes, there's always a check and balance. So if the decision, defense lawyer thinks that we have been a little bit careless with our investigation, this is not the correct way, we have the appeals court. So in our appeals court, you can appeal a judge, an investigation judge procedure. So for example, they asked me to go to a certain place to investigate, and I said, no, I'm too busy. I'm not going to go. But it's all done in writing and paper. So they can appeal my decision to refuse certain investigation to the appeal court. Or if I question certain witnesses and my tone was not correct and I, showed that I was biased or something, and the defense lawyer thinks that I was biased, they can appeal that to the appeals court, and the appeal court will decide whether the investigation judge stays on the case or they change out the investigation judge based on that. And if certain procedures are questionable conducted by the investigation judge, even upon trial, the defense lawyer can request the Court of Appeals to invalidate the procedure. So when a procedure is invalidated, the trial judge does not get to see the result of that procedure. It just disappears. The procedure doesn't exist in the case file anymore. So so the whole idea is there's still a whole lot of check and balances. The investigation judge, as much power as they have to impact and influence criminal procedure, still has a response and duty to both sides, as well as if we do certain things that's against our code of conduct or against biasness or impartiality, they can always bring that up to the Court of Appeals. And a panel of senior judges, all three, will look over the complaint against us and decide whether we continue or not. And too many complaints of improper conduct of investigation will always be against our performance. So you have to put the difference between improper investigation and just your own decision making. You've done proper investigation, but your decision is something that people are not happy about. That's different. If people are not happy about your decision, it doesn't matter. You're still protected. But if you've conducted some misconducts, I don't know, very friendly with the witness or do something that you should not be doing that impacts the partiality, that can impact the result of your investigation, you can be reviewed for that for sure.
Okay.
Thank you.
Okay, thank you, Judge Jessica. I hope it answers your question, Bu Nunu.
Yes, but she hasn't answered my last question.
Oh, yes. Jumping institutions.
Yeah.
Yes.
So I did not jump institutions without training, I have to say. So when you go into military court, you have your own training. And as soon as I left military court, I was recruited for ministry, for the civilian side. I have to undergo the civilian judge training for 3 years as well. So it is very common in a small country that is developing like Cambodia to have people transfer over to different sectors based on necessity. But as far as a professional corps of judges like Cambodia, I still had to undergo all the civilian judge training, which on top of that, I had undergo my military judge training already. So it wasn't very much different, except that you just wear different clothes in the courtroom.
I see. I see.
Yeah. Any other questions you have?
No. I hope that I can see you in person one day so we can discuss a lot.
Absolutely. Please come to
Okay.
Cambodia, or I hope to go see everyone soon.
Yeah, okay, thank you.
Thank you.
Okay, for the next one, we have Mbak
Yes,
Amel.
Mbak Amel, yeah.
Hello, thank you. I have a particular interest right now in the criminal procedure because Indonesia is actually going to amend their criminal procedure code, and I think we don't have a robust regulation on judicial scrutiny. So in my mind, the investigating judge is part of judicial scrutiny of the criminal procedure, right?
Yes.
So I really want to know about. Wait, I write down my question. So I want to know about how is the division of power in the context of the judiciary in Cambodia? Is the prosecutor responsible to the judicial branch or to the executive? Because like in Indonesia, the police and the prosecutors fall under the executive power. It's not part of the judicial branch. So I want to know about that. And I also want to know when was this investigating judge established? And so as you have told us, if I'm not mistaken, it is regulated in the criminal procedure, right, in Cambodia. So I want to know when was it established. That will be my question. Thank you.
Okay, I might need your last question again, but basically our prosecutors are still responsible, actually very different. Just like the French system, we're still responsible to the judiciary. And our training as a judge, we train with prosecutors, actually. So, and in the investigation judicial investigation procedure, I talked to you a lot about the investigation judge, but I didn't talk to you about the prosecutor. The judicial investigation happens with the prosecutor. So the prosecutor is the person that submits, and we're very limited with what the prosecutor submits to us. Only if the prosecutor submits to a judicial officer do we investigate. But alongside the prosecutor, all our procedures are done with the prosecutor. So if we go for search and seizures, we have to tell the prosecutor to come with us. Do it together. We have to tell them. So if we decide on detention, we have to do a mini hearing with the prosecutor giving their opinion, official opinion on it, their formal legal opinion. If we do anything to do with evidence, we need the prosecutor to give their legal opinion on paper, what it is. So everything is a check and balance still. As much as you hear that the investigation judge has all this power, but everything is still done alongside with the prosecutor. because it's a way to ensure that there is a judge that's looking out for the fairness, but also a prosecutor that is involved in the interests of the state at the same time. So it's a check and balance between these two, talking to each other about what is fair, what is partial. And at the end of the day, even before we submit to trial, the prosecutor has to give their legal opinion on what they think. But it doesn't bind the judge. But of course, it's basically putting two people on the case with the judge leading. So in that case, our prosecutors, whereas the law enforcement, the police, they completely work for the state. But our prosecutors are still responsible to the judiciary. May I get your second question again?
Okay, but before we go to my second question, I still have questions related to that.
Okay.
So in adversarial system, there's a admissibility of evidence trial, right? So it's kind of the same with this
Very
investigating judge, right? So that's interesting because in Indonesia we don't have that. Judge doesn't have any power or any, how do we call it, any duty to scrutinize the evidence before the trial. We just do it at the trial. So I think it's really important, and because it also can make the trial becomes more brief, I believe, and effective and efficient, because you have people that has already scrutinized the evidence. I think it's, yeah. And my second question is,
I have a question back to you though.
Oh yeah. Okay.
Arrest warrants and detention, where does that power lie in your system?
The arrest, I think it's in the police, I believe. Yeah, right. Because for the arrest, yeah, but for detention, it depends on where the
process is.
Yeah, it depends on the process. Like if the process is still in the police, so the detention grant will be the police responsibility and so on.
Oh,
yeah.
okay.
Yeah. So in Cambodia, it's for the court. The arrest warrant.
So the police do not issue arrest warrants. They can summon and they can hold someone temporarily for up to 48 hours, but beyond the 48 hours, to take a person's liberty needs to be a court decision.
Oh, okay.
Yeah,
That's interesting. Yeah.
So even if they summon someone in and they hold someone temporary, it needs the agreement from the prosecutors. The police cannot just pick someone up and hold them on for themselves. It's designed to prevent, because in every country, the people with the guns are always the most powerful people. So I think Cambodia designed the system so that we never have the problems of people with the guns having too much power with human rights issues.
Okay. My second question is, when was this investigating judge established? I mean, like, when was it took into effect?
So I would say it goes all the way back to when we first designed our criminal code.
Okay, when was it?
Because of the French, in the 1992 when we.
Oh, since 1992. Okay.
So we had a whole, if you remember, we had a whole genocide where our whole system collapsed and we have to rebuild ourselves, and we never really developed a code until the 90s, and and even under the development of that code, we use the French. It's almost like, if you look at the French system, it's almost the copy paste of the French system, because it was using the French influence that we had, the legal influence that they had over us. Now, the investigation judge in France is used less now and reserved for more serious and complicated crimes. But we're gonna work towards that as well. I think we don't need to use the investigation judge for every crime at the moment.
Yeah. But do you have like other judicial scrutiny other than investigating judge in Cambodia? Like in Indonesia, there is what do we call it?
Pre-trial.
Pra-peradilan, like
Pra-peradilan, yeah,
yeah,
pre-trial.
pre-trial
Yeah.
to trial whether for example, whether there is a violence during the
Arrest.
process, during the arrest or something like that. Do you have that also?
That will be the investigation judge.
Oh, that will be the investigation.
Yeah. So we will look at what the police did and valid or invalidate it.
Mm.
What
So
the
you
pol-
don't have other system or other methods to scrutinize that part
No.
other than
Yeah, that will be the investigation judge
Okay.
deciding whether abuses of powers have happened based on the rights of the individuals.
Okay, cool. Thank you so much.
Thank you for joining and asking.
Okay. So I have a little bit of follow-up from Mbak Leila. She's a judge candidate from Jombang.
Hmm.
She asked privately to me that do you have a different pre-trial chamber and investigating chamber, or it's the same like you explained before?
Yeah, so technically a judge right now, ideally in the future, I know there's hopes to, if you're investigating judge, you just investigate. If you're a trial judge, you just a trial judge. But right
Mhm.
now, my chamber is both investigation and trial chamber. So I will trial as well. So we don't
How
really,
about pre-trial? The one that you explained before, which examining the abuse of power and such. Is it already actually also fall under the investigating judge too, or you have another different division of pre-trial?
no, it will fall under the investigation judge too. So
Okay.
when they come into investigation, the parties will submit for complaint to the judge that we were tortured for this confession from the police, and we, ask for you to investigate this. So we will also investigate. And as an investigation judge, I can nullify what the police do if I feel that but I have to do it with a reasoned decision. Again, investigation judge have a lot of power, but you have to have a reasoned decision. You cannot just decide with no basis. And my decision and my reasoning is the grounds for whether I've done it correctly or not. So they will always look at my decision making. If I decided to nullify the response of accused A at provincial police, because and I have to say the person came in with marks on their bodies. They talked about them being forced to, and they have, sound clips of them. So with enough evidence to show that they have really been tortured, and that I will present it to the prosecutor, and the prosecutor can file a different claim against the police or not. But in my case, it will be nullified based on my decision.
Okay, I think it's answer the question, yeah, Laila, yeah. Okay, Judge Jessica, do you still have sometimes, because we still have one last person who raises his hand. Okay, is it okay?
Absolutely. Let's go with
Okay.
one last question.
Okay, one last question from Mas Jeffrey Pratama from Tual. Room is yours.
Thank you, Justice Aziza. Greetings, Justice Jessica. I intentionally went last because I wanted to give my fellow other justices a chance to speak beforehand, because I feel like if I start talking, I might take up a bit too much time.
Should I start writing down then?
No. My question is actually fairly simple. By the way, thank you for your explanation, brief explanation on answering our questions about the Cambodian justice system, about the life of being a Cambodian investigating judge, and so on. Thank you for your time as well. My question is fairly short and simple. Well, not simple, short. So, as my fellow Indonesian justices know, there have been a couple of judiciary reforms here in Indonesia, and some are, you would say, quite controversial, such as I think in late 2024, sorry, in mid 2024, the Indonesian Parliament ratified the amendment, the Constitutional Court amendments for the reduced justice's tenure, and probably much more controversial, I think, in 2022. Yeah, in 2022, they passed the criminal code that criminalizes cohabitation outside of marriage, which is, I won't comment on that. And also about defaming the president, which, again, I will not comment on that because, again, it's quite controversial. My question is mainly, in Cambodia, basically, do you have any recent judiciary reforms that are as controversial or as major, like major news in the last 5 to 10 years that you would like to share, like that you think we in Indonesia should know? Because Indonesia, when we make justice reforms, it's usually not that controversial, except a couple of occasions in which those two things that I mentioned are quite controversial, as you can imagine.
So I think that there's a lot to unpack with this, but I think if in Cambodia, the judicial is probably the baby of all the institutions. We had to rebuild our country. So when we rebuild our country back, security was what mattered. Living was what mattered. So we focused on all those other institutions to survive. And we left the judicial to itself for the longest time without giving it proper money, without giving it proper power, without giving it any support. And therefore, social justice suffered. Social justice suffered for a good 10, 15 years before we decided we've got proper security, we have enough food on the table, we need to make sure that our system works for everybody for the long term. And that's when we've decided with this new government to focus on judicial reform. So the biggest reform was to make our judicial more professional. And professional means keeping a very strict code of ethics. Again, like I said, my decision is protected if I am doing it under my professionalism, but it's not protected if I'm doing it under a breaking of my code of ethics. So the one thing that was very, 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 I would say, contentious for the judiciary was this new mechanism that the government developed this new mechanism. It was a policy, it was a legal policy to reform of receiving complaints about judges. So now, if you have a personal complaint about judges, you can submit it to the government, and the government will submit it to His Majesty to review. So before, you had to only submit it through His Majesty directly. So if you had an issue with judges, with, say, my impartiality or something that you think is not unbecoming of a judge, you submit it to His Majesty, and he will review it. But now the Ministry of Justice opened up a different channel where it's easier through social media, through everything. They will receive complaints about judges. And in that, in order to show that the complaints were real or not, they investigate every complaint. So I've been investigated maybe like 7 or 8 times already, ever since this mechanism opened. But out of all the thousands and thousands of the complaint investigated, only 2% were found to be of something substance. So when I'm super busy, like I got complaint because I was super busy and I'm always away on meetings. And the complaint was that I'm always away on meetings and I'm slowing down the investigation. That's mainly all of my complaints. So they will investigate it to show that whether I am violating my ethic as a judge or not. But it's still, this caused us a lot of time because every complaint I get against me, I have to do a big report. And then I have to copy my whole case file to show that everything I've done is procedurally proper and I've not been biased against anyone. So this was something that was very contentious for the judiciary, because now, on top of the load work that we have, someone asked me, what are the other non-judicial? I have to stop and explain myself all the time. And so this was the part that now we have administrative, I would say, government oversight on us. But it's a temporary mechanism designed for 2 years to show the results that the complaints against the judiciary are not found. So I think out of all, they've done a 1 year summary of it, is that 2% were found to be, yes, the judges was acting out of professionalism. 2% of the complaint, all the 98% were just people who come to court or just unhappy people in general. So that was something that is quite contentious for us in our judiciary. And other things is that right now there's a big focus on the judiciary to do a lot. Like, I'm asked to do a lot. I'm asked to do all my cases really quick and really fast right now, because we have, justice delayed is injustice in a form. But I have 527 cases to do a year. So it's going to suffer at some point. So at that, we understand that with a developing country, everyone has to do more than I would say a non-developing, a developed country would already have enough judges to do everything. But one of the reforms is now asking for us to do faster, but we're doing so much. So I think that's something that the judiciary feels a heavy burden upon at the moment. Now, there's a couple laws that have been passed that I think is also, I would say, fishy. I also would disagree upon laws like making extramarital affairs criminal. Yes, to me is an issue. Like, to me, I think that's a problem, but to make it a criminal problem means that we have to deal with spousal fights all the time in court. And to me, I think it's just I don't think it solves a social problem as much as the other criminal crimes that we have. So yes, there's a lot of stuff like that we have that us judges will be like, I wish this wasn't a crime, so I don't have to spend my time on this, and I can spend my time on bigger social solving bigger social crimes that actually, I don't want to be, looking into spouses, what they do outside of, because to me, I don't think that's a huge danger to society, like the other crimes that we should be spending our time on. But, us judges, we have our personal opinion, and then we have no legal opinion on anything. So I like to say we always have our personal opinion as judges, because we're still human. We always still have our personal opinion, but we can never have a legal opinion. Because once we have a legal official opinion, that becomes something that can be used against us in our courtroom.
Yep, that's 100% true.
Yes.
Our legal opinion is our verdicts, and that's
Our
it.
verdict, our
Yeah,
decision.
our legal opinion is our verdict.
Our
Other than
verdicts,
our
and
verdict,
that's it.
that's it. We cannot have any other opinion. They all
Yeah.
have to be personal opinions.
Yeah. You also absolutely cannot have a political opinion.
No,
In
no.
no way, shape, or form are you allowed to have a political opinion if you're a
Absolutely
judge
not.
here in Indonesia.
Absolutely not.
Okay.
Very interesting question, though.
Okay.
Thank you.
Thank you. Thank you, Mas Jeffrey. Thank you, Judge Jessica, for the answer. And as you say, criminalization of everything, it's actually give us more burden in our job, right? It's another whole new problem for us then. The new law, new criminalization, new things that is criminalized, then it means more cases for us. So it's
Yeah.
a burden for us. Yeah. Okay, so I think that's all for today. Maybe a bit of closing from Judge Jessica here to us.
So I have no serious thing to close on. However, I am very honored and delighted to be a part of our dialogue today. It's so interesting that Indonesia is also reforming soon,
Mhm.
and there's a lot of inputs that can go into that regarding sort of the checks and balances of different entities. But everyone here has such an interesting intake and input on everything. And this is why I am so privileged to be here to talk to you today. And I hope you'll let me join as a participant in other dialogues too, please.
Of course, our door is always open for you. And regarding that, there are some people that asking if it's okay that you share your contact, maybe email or something to us.
Absolutely. So
Okay.
Judge Baggis has my contact. I am
Okay.
happy to connect and talk to everyone. And
Okay.
I hope you come to Cambodia, and I hope when I go to your different province, I can go visit you. Your
Okay.
individual court too.
Okay, we'll be waiting
Sure.
for you. Okay, I think that's all. Yeah, Mas Boy.
Yep. Thank you so much, Judge Jessica, for your awesome insight and also the materials. So we have done our discussion about the judicial investigation itself. You have mentioned about the accuracy, check and balances, also the state power itself in that judicial investigation. Thank you also to all the participants here, especially because this program is held by FKDP, Forum Kajian Dunia Peradilan. So it would be interesting if you able to come again with us to discuss and make so many, like interesting insights from now on and yeah, in the next time as well. Thank you so much for all the people here, our distinguished speaker. Hope you have your really nice weekend this
Thank
week.
you.
Thank you.
Have a
Thank you
good
so
weekend,
much.
everyone.
Before we off, can we take a picture together? Can
Sure.
everyone turn on the camera so we can take the picture and we will post this in our Instagram later, in FKDP Instagram, I mean. Okay, Mas Bagus. Take the picture, please.
Okay, in 1, 2, 3, say cheese. Once more. 1, 2, cheese. Okay, wonderful. Thank you, Jessica.
Thank you very much
Okay,
to
thank you,
Thank you
everyone.
Judge
so much,
Jessica.
Thank you,
Judge Jessica.
everyone.
You're